looking at the contaminated land instructions and the issues that have been already pointed out in the submissions, can you confirm developers' Phase 1 contaminated land survey states that remediation of land must be agreed with the local planning authority and documentation discharged prior to the commencement of works?
Through you, Chair. The conditions in relation to contaminated land on the original permission, they do have a separate application which has been submitted to agree those details. They've been carried through to this variation application as well. Obviously, everyone's aware that they've commenced without this scheme having been agreed, and as soon as the council became aware that they had commenced without the relevant conditions having been discharged, we went out on site and got construction to stop effectively. So I'm not sure if, regarding the technical aspects of the remediation itself, it might be best getting some advice from the environmental health colleagues. Thank you, Chair.
Thank you, Mr. Healy. Can I ask, is it Mr. Martin who's representing environmental health on this one? Chair, if you could bear with me on this, because it does link together in the point that I'm going to be making. So, Mr. Martin, can you confirm that on this site then that they have effectively they have committed an offence by a breach of the Environmental Protection Act? By commencing development, they've actually started moving ground and they've put in footings, and building works have been put into the ground, and the application to discharge the contaminated land conditions have not even been, they've only just been, in fact they were submitted, from what I can find out, they were submitted after the works had ceased. So they hadn't even agreed the working conditions of that site, and the remediation of the contaminated land hadn't been agreed and discharged before they commenced work. Have they committed an offence?
Thank you, Councillor and Chair. In terms of an offence against the Environmental Protection Act, no offence has been committed with regard to contaminated land. Any potential issues of condition breaches are dealt with under the planning regime, so it would be appropriate for a planning officer to comment on any sort of legal breaches and any offences in relation to contamination, because the contamination on this particular site is low, but it's been dealt with through the development control process, not through the environmental health powers.
Thank you for that, Mr. Mark. Councillor McCann, I'm not sure whether you've still got more questions.
Well, I have, because I'd like to follow on from what Mr. Martin's just said.
Oh.
Sorry, thanks for that. Martin, are we saying then that this site isn't a Phase 2 category contaminated land site? Because I thought it was. And I thought for that to be if that was the situation, that the discharge of the contaminated land had to be done prior to any work starting on site. If they haven't done that, and in the remediation of the contaminated land, it does say it must be agreed with the local planning authority. That to me says that they have committed an offence, and I don't think it's under the planning rules. I think it's under the environmental rules.
Thank you, Councillor. This site is being dealt with in terms of contaminated land through the development control process. It's not being dealt with through environmental health, environmental protection legislation. So whilst it is following the sort of guidelines of Part 2 of the Environmental Protection Act in terms of the manner in which testing is carried out, the manner in which remediation is carried out, it's not deemed a special site, and we haven't identified it as a site which requires proactive inspection and associated remediation. The site is being dealt with through the development control process.
Okay, I don't think that's right, but anyway, okay, I'll take that for now. Thank you, Chair.
Okay, we'll bring Mr. Mackenzie in at this point.
Thank you, Chair. First of all, Councillor McCann is right in the sense that works have commenced on site before being properly discharged, and we would be within our rights to serve a breach of condition notice to remedy that. However, as with always, and particularly now, the government's advising us to be extremely pragmatic about the use of enforcement powers, and in this particular case, they've stopped work and they have submitted a retrospective information about the discharge of those conditions. So we're dealing with it as part of that process. And we're also tacking on to the back of that issues around the regulations on the contamination as part of the development management process. Thank you.